Welcome to another episode of the Criminal Law Department Presents podcast, a production of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Every 2 weeks, we release a new episode. Today's episode is a grab bag where we discuss an important topic in military justice. Please note that these episodes may contain facts and circumstances surrounding a criminal trial, and listener discretion is advised. The purpose of today's podcast is to discuss a military judge's perspective on various courtroom topics, such as etiquette, filings, and how to make the process run smoother and more efficiently. We're honored to be joined today by Colonel Robert Shuck, a military judge currently serving in the 4th Judicial Circuit. Sir, thanks for joining us today.
Glad to be here.
Today's virtual gateway sessions an audio roadmap or guidebook for practitioners on both sides of the aisle, and our goal here at the schoolhouse is to provide a quick hit point that will immediately improve performance and practice, as well as create judicial economy across the field. We'll cover any topics that you would normally cover in a gateway session. And sir, I open it up to you, whatever you would like to talk about first, and we will go from there.
Sure. Quick disclaimer, this is just my perspective that I've developed over the past almost 6 years on the bench, and not the Army's position or not the judiciary's position. And every judge has got different wants and needs, so to speak, with regards to improving of advocacy. And so one of the things that I think is helpful, given that we're in a podcast environment, was first talking about technology in the courtroom. I have seen some incredible use of software, litigation-specific software tools that are out there in the courtroom. A quick plug for our Bridging the Gap team sites, which has got almost 360, I think over 360 members as of this morning. So if you're not a member, you should jump on that, because a lot of these topics I've already, myself or other judges have already commented about. But certainly I've seen some incredible litigation software tools in the courtroom that have really helped out, whether a defense attorney walking through a direct of their own client or a cross-examination utilizing other exhibits that have already been admitted. It's been, there's really some interesting software packages that are available for practitioners for use in the courtroom. And as I like to tell everybody I can, whether it be my senior leadership or the attorneys that practice in front of me, digital evidence is not going away. And so if you're going to need to get familiar with and be able to manipulate digital evidence so that you can make your presentation the best it can be. And if you're simply not comfortable or not capable of working with a digital photograph, a digital recording, then find somebody within your office that is. But I encourage you to certainly, there's many YouTube videos, and there's many online classes that you can take that can assist you in putting together something that could drastically improve your utilization of technology in the courtroom.
Sir, having sat through several trials and observed the use of technology, do you find that the panel members like when counsel use technology to improve their performance? Additionally, do you find that it enhances counsel's advocacy techniques when they do use it?
Yes and no. So what I like to tell counsel is think outside the witness mouth when presenting your evidence. And so that means that, usually the best way to tell a story isn't by someone saying every single word of what happened. It's usually a better story is one that involves some sort of visual or a demonstrative. One, it makes your testimony more interesting and memorable when you do use technology in a good way, but it also becomes distracting when counsel, for instance, will just throw up slides with 100 words on the slide and then try to also engage with the panel members. And you can see the panel members do the same struggle. And I've actually stopped attorneys when it's a judge alone trial. I'm like, look, I can either read your slide or I can listen to what you're saying. I can't do both at the same time. And so you have to incorporate your verbal arguments with your technology arguments to allow the technology sort of, so to speak, to sink in, and also to realize that you're not briefing them in a manner that they can take the slides home with them. You're using this not as a resource that they can then take back into the liberation room, but to emphasize certain points within your argument. For example, say you're a prosecutor and you had a 3 hour CID confession, but there's one sentence in there that the accused would say, like, I'm glad I committed the crime. I perfectly intended to commit the crime when I did it, and I would do it again tomorrow. And so that would be a nice snippet. Then, if you had the capabilities, because you've taken that information, you've taken just that portion uh, from that, and you put it within your closing argument. And so you can start and maybe end with that very powerful, very highly probative evidence, and it helps the panel members with what I call stickiness. It helps them remember. It certainly helps me remember that there's a very powerful piece of damaging evidence for the accused in front of the panel members. That would be, I think, a good use of a person curating the evidence that's already been presented and putting it in a format that's more digestible, so to speak, for the panel member. What unfortunately happens is that there is no curation uh, process done. Instead, they play everything rather than playing the snippets that are best suited for their case, or highlighting or giving the entire photograph rather than highlighting that particular portion of the photograph which you want the panel member or you want the fact finder to pay attention to. And so you can overwhelm the fact finder with just failing to curate, failing to edit your work, so to speak, or you could use it as a tool within your arsenal to better persuade them to, persuade them to get the verdict that you desire.
I think it's an excellent point, sir. I think that Chiefs of Justice, Senior Defense Counsel need to, when they're developing their training plans for the quarter or for the year, work in digital evidence concepts, presentation, admitting the evidence, and as you mentioned, curating the evidence. That way, you enhance your presentation of the evidence to the fact finder to reach your ultimate result. And sir, before moving on, I just wanted to note that the name of the teams you mentioned is Bridging the Gap, and anyone that's in a litigation billet or advisory role can just go on to Teams and do a search for Bridging the Gap. You'll see the link to the group there, and it's a valuable resource. I've used it for about 2.5 years now, and I recommend everybody using it. While we're on the Bridging the Gap, there's often a discussion in there about arraignments and some, easy, quick points that both sides could really score either with the judge or their client about being efficient or professional. Do you mind touching upon some of the common errors you see at arraignments and how we can overcome that?
Sure. So the common errors, I've had counsel who've appeared for me in scores of cases, literally scores of cases, that still can't get through a simple arraignment script. And I got advice maybe 15 years ago from a retiring civilian, former retired senior NCO, who said they made it a part of their work life to make the routine routine. And so I think the struggle is people don't understand what the whys behind of the things that we do within an arraignment session. There's certain things that there's a reason for everything we do, for every word, almost nearly every word that's said during an arraignment script that has legal consequences for the entire process. And so maybe taking a step back, looking at the reason why we do things the way we do, and get an understanding of the why, and that way you better understand the process. You can make yourself look better by making that routine a routine. Like if you don't know your detail and qualifications script. It just makes it so much easier and comes across much more polished when you're able to roll that right off the tongue. It shows confidence. It shows confidence to maybe you have some victims in the courtroom that are normally even attending even the arraignment sessions, or if it's your client that you've done this before, and it also helps the judge. It's like, okay, I'm dealing with somebody who this is not their first rodeo. And so when you don't have that, and I know by heart, and I can look at people in the eye. I look the accused in the eye. I've detailed myself to this court martial. I have I have not am acted in any manner that's might tend to disqualify me as court martial. Does either party wish to question or challenge me? You know, having those kinds uh, of of tidbits, or the piece of the arraignment, accused and defense counsel, please rise. Sergeant Snuffy, how do you plead? Before receiving your plea, I advise you that any motion to dismiss or grant other appropriate relief must be must be made at this time. Your defense counsel will speak for you. If you can just get the short bits, the ones that occur every single court martial, then I think you're going to instill confidence in everybody in the courtroom, to include yourself. And so make that routine. But I have still struggled with some counsel who don't understand what an Article 30A session is. And so we'll say something and I'll have to correct them, like, yes, there was a 30 alpha session in this case. Or, uh, no, you got the wrong convening order. No, that's not I need the specific general nature of the charge, not just the number of the UCMJ article, those kinds of things. And there's been a really good posting by other judges on the arraignments. But but if you make it routine, if you get down the same things that you're going to answer or say in every single court martial, you're going to be more confident, and that's going to instill confidence in everybody in that room.
Sure. Then the next topic I wanted to really dive into is pretrial practice. And as you know from the Bridging the Gap Teams group, we could talk about pretrial practice for hours. So I want to narrow it down to two things: motions practice and then pretrial conferences. And so focusing on pretrial conferences first, what is your observation in the field about whether or not counsel are doing the pretrial conference right? Are they using it to their fullest advantage? Or are we just using it to check the box? How do you see pretrial conferences working, and how do you think it can best help the two parties resolve issues before trial?
So, interestingly enough, I had a one of the captain's trial counsel who got out, who's now practicing in Arizona, commented about their pretrial conferences, which involves a judge that is not a part of the case is involved and will give commentary about the case. And of course, we're prohibited from that, from doing that in the military practice, specifically prohibited. But he had mentioned how helpful it is for pretrial conferences to hash out and really to get to the heart of the matter. I'm not a member, or uh, am privy to the conversations, but I do know when it goes well, when you've got experienced and, I would say, probably sage counsel on both sides, which really help the process because they're able to focus on what the real issues are in a case, and are able to litigate amongst themselves and resolve things without necessarily the judge getting involved. And so I find them to be helpful with counsel who know what to fight about and what not to fight about. And when I think it's more of a check the box, it's clearly evident when you're asking, you ask the counsel why, either during an 802 session or on the record, like, why is this an issue? I mean, it seems like you both agree, you both agree on this particular fact. Why couldn't this been hashed out beforehand? You kind of get the sheepish looks from the counsel, and that they've certainly made it personal, and they, for whatever reason, can't work together on a matter. We don't have the forcing function that a lot of the civilian courts do with regards to pretrial conferences. But if counsel, I think a wise counsel would realize that they're limited in, they may have unlimited resources of the federal government behind them, but they've only got so much of themselves and their own time and personal resources to on every single possible case and issue. And if you can narrow down the issues and focus on those things that are most applicable to your case theory, et cetera, I think you could find that pretrial conferences could be very, very valuable in resolving something. Because, like it or not, the parties are going to have to are going to have to work together and are going to be involved in the case on one form or the other for the rest of the lifespan of that case. And so, and also, realize that most of the cases still do go to some form of alternative disposition, whether it's Chapter 10, whether it's a dismissal for other reasons, or if it's a guilty plea. And so that also, by having a pretrial conference and utilizing that time to work through the issues, you might get a mutually agreeable settlement of the entire matter. And so it's certainly something that behooves people to approach with an understanding that by playing well with others, you can still achieve the results, the best possible outcome for the position that you're advocating.
There will be issues that you can't resolve, but most of the time, the pretrial conference is a great way to just resolve discovery issues, witness issues, expert issues, other issues that you would normally file motions over that would just waste time and take up the court's time. And by resolving those issues ahead of time, it allows you to focus on what you really need to focus on as either a trial counsel or defense counsel, which is preparing your case and ensuring if you're a defense counsel, your client gets the best defense they can get. I think what's important to note from your point is, since we don't have that judicial forcing function that we find in a lot of civilian courts, I think it's important for the chiefs of justice and the senior defense counsels out there to use the pretrial conference as kind of a gauge of how your counsel are doing. You can use it as not just as a tool to see if good relationships exist, but also their advocacy skills, because sometimes you can resolve issues in a pretrial conference through negotiation and advocacy without ever stepping into a courtroom. So I think it's an effective tool for the supervisors out there to evaluate their counsel as well.
Exactly.
So moving on to motions practice, sir. I know there's a template in the rules for practice before Army courts martial. What are some things you often see in the filings when we eventually do get to motions that could better our practice that are just unnecessary?
Oh, well, I mean, there's certainly been a lot written on this, and I believe the several members of the judiciary, myself included, have an article that's going to be out with the Army lawyer on this subject. So I would encourage you all to read that. But there are certain things that I think are almost at this point hilarious, with regards to some of the things I've seen with the briefs. First, unfortunately, I see a lot of canned briefs and responses, which are almost worthless. I've actually seen counsel send me refer to multiple cases that are on the docket in the briefs. They would conflate one case with another case, and it just comes across as just bad, certainly not persuasive, that you don't even know what case we're on. All the archaic language that somehow has creeped in to our pleadings, like the comes now. I've essentially banned it from the briefs, trying to encourage people to stop that, using that language, or else I'll make them say it during their oral argument. Like, okay, you haven't said comes now, I can't listen to you unless it's like an all capitalization. None of that is persuasive. I don't know any judges or anybody who thinks that using archaic language that has absolutely no purpose is any way persuasive. And so, and way too many words are used. I know it's hard to distill down your arguments sometimes into less, but the less is more persuasive than the more, almost all the time, almost all the time. And the facts matter a lot in for a trial judge. And so a lot of what I read are a lot of what I would call law review articles that are almost worthless unless they're advocating for a change in the law, which I got. I mean, I certainly understand for those are kinds of issues that pop up. But if it's something that's fact specific for a case, like a motion to suppress, I don't want to hear a Fourth Amendment dissertation for 5 or 6 pages. I need to know what are the facts because your trial judges, that's where you get the most discretion. That's my abuse of discretion is my findings of facts that I find. And I will tell you, I had a very heated motion to suppress case last year involving, and we had several witnesses. The accused took the stand. We had several law enforcement, and the government brief had the facts as one way. The defense brief had the facts as another way, of course, and then what actually came out at during the 39A was a completely different set of facts, and yet the counsel just fell back on their briefs and never argued once what the facts that actually came out during the hearing should and how that should be applied to the law. And so rarely do I actually ever hear counsel even saying this is why my fact should be believed over my opponent's. Now we do it all the time in front of members and in front of judge alone cases for findings, but it's like they turn off that function in their head and say that we should only talk about the law rather than the actual facts that make up most of the decision making process for your trial judges. So, if your findings of fact and conclusions of law is are the motions, I'm not going to get any discretion for me saying this is what the law should be, right? Because that's going to be a de novo review by higher courts, as it should be. They're the ones that know, and just as good as I am about what the law is. But I've actually seen the witnesses. I've actually heard the testimony. I've actually made credibility decisions. And so why counsel never speak about or try to persuade me on the facts with their briefs, I just don't know. I to this day, in 6 years, rare is the advocate that will stand up and say these are the facts that matter in the case, and this is why these by whatever standard I have to use, like preponderance of the evidence is a common one for motions. This is what I should focus on with regards to my findings of fact that I'm going to make in my ruling. And so I'm going to do a foot stomp here. Don't forget the facts. The facts actually matter. And if you could articulate why your facts are better than your opponent's facts, you're developing two skills. One, you're developing better motions practice skills, but then two, you're also developing skills that you'll later use during a contested trial.
We've been focusing a lot on some of the improves that we could do. What would you say is one or two things that you would highlight that counsel are doing well and you would like to continue seeing them do throughout the entire trial process?
I think one of the things that I've really enjoyed is when I was at Fort Riley, when you were there as a prosecutor, I made a comment about, it would really be nice if for stipulations of fact that we focused on a little bit more than just the words, and, maybe pictures with illustrations and would be helpful. Once I said that, I started getting a lot of stipulations of fact, for instance, with regards to photographs, including photographs like of crime scenes. the books that are more interesting tend to be the books that also have pictures. Like, you read a real true crime story. It's one thing to read the descriptions of the settings and the parties, but it's also very interesting. Always in the middle of the book, there used to be, all these pictures of the actual people that were involved and the places that were involved, and that makes it very interesting for the reader, and it certainly makes it much more interesting and helpful for everybody involved. It helps the accused get through providency, and it also helps the judge understand the case better, because all the judges get are the referral documents. We don't get anything with all I know is what's on the charge sheet, and so the more information, the more context you can give, the better. And I think we've done a really good job, and we've come a long way in the past 6 years with regards to our stipulations of fact. I think that kind of mentality you can put into all areas of your practice. Like if everything doesn't have to be come out of someone's mouth in order for it to be persuasive. You could incorporate pictures. You could incorporate demonstrations. You could incorporate sound, smells. I've had smells. I've had weight used as a demonstrative. All those are thinking outside of the witness stand with regards to putting forth and understanding a case better, using more of your senses rather than just the written or spoken word.
Sir, you kind of mentioned it at the end of your answer there about demonstrative evidence. Do you see it being used enough? As you mentioned, it's very persuasive. And so if there's any tips for counsel on using demonstrative evidence, I think that would be helpful for the field.
Sure. Here is an area that's ripe for innovation and disruption, is our use of demonstratives. Here's what I always thought that attorneys offices should have. They should probably have a demonstrative kit bag in their office, which would cost a lot less than a cost of one expert, which would include things like maybe one of those fighting dummies, which have it's like an upper torso and head, or some tape measures, uh, a life-sized body, for instance, different types of real tools, real cameras, for instance, not some of the cameras that photographs that I've actually seen, but think about cases, a SANE kit, for instance. All that could better tell the story that you want to tell in an understandable way. For instance, the I've seen so many people try to air strangle somebody in the courtroom, and it's just not. And they're trying to articulate it for the record, and they're trying to articulate what's actually being done, but it's not very helpful at all to tell the story. And so you have to take a step back and say, okay, what could I do and to tell and to make this story better? How can I tell this story in a better way? Sometimes it's maybe persuading the judge to do a site visit. I tried a case. I was a fact finder. I held court in Abrams tank once when I was in Korea, because I was persuaded that and that was the scene of a crime, that you can't you can't understand the evidence unless you've actually sat in literally the tank commander's uh, shoes inside the tank. And that was just a phenomenal way to tell the story that party was wanting to tell. And they were thinking outside. They were actually thinking outside the courtroom in that instance. We recently, a couple weeks ago, had people think outside the courtroom and go and did a site visit at an alleged crime scene. Once again, it ended up being very persuasive for that particular party. Um, and so taking a step back and thinking, how can I involve different senses? How can I make this stickier, so to speak? How can I get the most likes in the minds of the fact finder with this evidence? And some of the most memorable evidence that I've ever had in front of me have all been most of them have all been demonstrative exhibits. that have stuck with my head, even years later. The the testimony, not so much. It's just simply is not as memorable or as persuasive as tying those two together. And I may one classic example. Almost 30 years ago, I watched a classic science fiction movie with a one of my first dates with now my wife. I watched Jurassic Park with her. I know 30 years later how to create a dinosaur from a sample of blood given from a fossilized mosquito from and mixed with frog DNA because it was a great demonstrative exhibit used by Steven Spielberg to help tell his story. Now, I still do not understand DNA as well from any of the DNA experts, of the countless DNA experts I have heard over the years, because every single one has not used a single demonstrative, not even a picture of a double helix. Show me, don't just tell me. Showing me is so much more stickier and much more memorable than telling me alone.
No, I 100% agree with you, sir. And I think that kind of flows into the final point we wanted to talk about is storytelling. What is your story? And so any parting words, sir, on storytelling theme and theory that you'd like to provide to the field?
Sure. One of the things that I put out, and there's some this not that slides that I've posted on the Bridging the Gap site, but there's some classic, and one of the things that is often forgotten is the sentencing case with regards to telling a story. Remember that your job is not to just dump a bunch of evidence onto the judge and have them figure out what's most important. There's been times over the past several years where I've looked at an often misnamed packet, the Good Soldier packet, for instance, and I'm looking at photographs. I'm like, why, out of all the photographs of this person's life, why are these important? Like, what am I looking at? Somebody didn't even know who I'm looking at, and why it ties into any kind of case theory. I've had government just dump entire investigations, criminal investigations, and call it aggravation. And I've gone back and said, look, I've not only are the witness statements in here contradicting the step of fact, which causes problems, but also they contradict each other. So whose statement am I supposed to take out of the statement of fact? And so realizing that you're a curator of all the evidence, you've got to go through and sort what's going to best fit your case theory. And I know it when I see it. When you don't have a case theory with regards to a sentencing case, it's very apparent. And I'll start with the defense. The defense will say, for instance, I've had two cases over the past couple of years say the soldier, once gets out of confinement, he's going to be a truck driver, right? This is a classic extenuation mitigation case. He's setting himself to be a productive member of society in a field that's, we need a lot of truck drivers in the country, right? And so I will have an unsworn statement where the soldier will say, I want to be a truck driver, and that will be it. And then you're just left, okay, well, you've just told me you want to be a truck driver. 2 weeks later, I have a similar soldier that will also say, I want to be a truck driver when I get out, but then in his evidence packet will include a photocopy of his CDL driver's license, will show a completion certificate from a local truck driving school, will show how his current MOS in transportation ties well with an MOS crosswalk into that kind of field, showed that he graduated the top of his class in AIT involving truck driving, will show that he give me a job offer from a future employer, showing me that he's gonna, get out and how he's gonna become a truck driver. So even though the defense attorney and the accused, even if the accused never said a word and the defense attorney never mentioned it, what have they told me with the evidence? They've told me this soldier is going to become a truck driver when he gets out of confinement. And how much more persuasive is that? But instead, you get the same cliched, statement from mom that she loves the accused, statement that that he's going to be able to bounce back after he gets out of confinement, but not ever showing me he's going to bounce back. Never, rather just it's always tell, and not enough showing. One that stands out was a case I don't know if you were involved in, but it was clear that the defense attorney's theme was, he wants to stand as general deterrence for other DUIs. And so he ended up taking a picture of his crushed truck, blowing it up, as well as like a statement of him accepting responsibility, and then testimony by the company commander about how he posted these pictures on his own in the company day room or something like that for every other soldier to see. And that defense attorney flipped the script and was able to say, look, he is standing before you today as general deterrence for other people. And so instead of, sending a message, the government wants to say that he can be sent a message by giving him a harsh confinement. Look at all the steps, the very powerful steps he's already taken to send a message. And it certainly was very, very powerful and very unique way of telling and forwarding that kind of case theory. So bottom line is, have a case theory, have a case theme, what happened, and then what is your theme going to be? And then ask yourself, how can I show the fact finder that this theory, rather than just me telling them this case theory? And I think you'll find a lot more success.
Sir, I want to thank you so much for joining us today on this episode of Military Justice Grab Bag for the Criminal Law Department Presents podcast. It was an honor having you, and I appreciate your advice and comments to the field. Any last parting words you'd like to say before we end the show?
I think you captured it. As I said, there's a lot of room for innovation within our practice, but you don't have to come up with creative ideas on your own. Look at what our civilian counterparts are doing in the case, and look at and certainly utilize the team site. If you're not already part of a defense or a prosecution team site where you can share ideas and best practices. I was using MillSuite 10 years ago to share ideas across the defense bar that we had in Korea. And that's, don't keep all these good ideas to yourself. Continually improve the practice. And then no matter what you do, make it better. Pay it forward and encourage innovation wherever you can find it. And I think you'll find better success that way, but you'll also make our entire enterprise practice a lot better. So best of luck.
Thanks so much, sir.
Thanks for joining us today for another episode of the Criminal Law Department Presents podcast. If anything you heard sparked a thought, we'd love to connect with you. Your comments help us create better future content for the field or the fleet. Reach out to us on Facebook or Instagram. The information can be found in the show notes for today's episode. The views expressed in today's podcast are those of the presenters and not necessarily the Judge Advocate General School